Leander is actually correct. Does a DOT officer, or any officer as a matter of fact, have to have a reasonable, articulable suspicion or probable cause to pull over a commercial motor vehicle? Or do they have the authority to randomly pull people over without that? A DOT officer or any officer must have reasonable, articulable suspicion or probable cause to pull over a commercial motor vehicle. The Fourth Amendment protects against unreasonable searches and seizures, and this protection extends to traffic stops. Generally, law enforcement officers must possess either probable cause of a civil infraction. So if you have a tail light out, keep those tail lights fixed. That gives them the civil infraction part. Or a reasonable suspicion of criminal activity to affect a traffic stop. And that's US v. Lyons. Now, all of this is for the Michigan, state and federal. Okay, this is the jurisdiction for the state of Michigan, the Circuit Court of Michigan, and Supreme Court. Okay, so US v. Lyons is a federal case. Requirement of reasonable suspicion or probable cause. In Delaware v. Prowse, which is a U.S. Supreme Court case, the Supreme Court held that random stops of vehicles without any specific articulable facts indicating a reasonable suspicion of a violation of the law are unconstitutional under the Fourth Amendment. The court emphasizes that stopping an automobile or detaining its occupants constitutes a seizure within the meaning of the Fourth Amendment. Okay. This also applies to commercial motor vehicles. Now there is exceptions, like for checkpoints, drinking and driving, stuff like that. For commercial motor vehicles, the requirement of reasonable suspicion or probable cause also applies. In United States versus Dominguez Prieto, the Sixth Circuit upheld the roadside inspection of a commercial truck conducted pursuant to a Tennessee law that permits warrantless stops and inspections upon a reasonable belief that the safety violation is occurring. The court noted that the requirement of a reasonable belief was crucial to the constitutionality of the inspection under the Fourth Amendment. In summary, a DOT officer or any officer must have a reasonable, articulable suspicion or probable cause to pull over a commercial motor vehicle. Random stops without suspicion are unconstitutional. So when Leander is talking about overweight tickets and they are just pulling the trucks over in Michigan, how are they able to articulate it? Where is their belief coming from? This is not what Michigan is doing. These counties cannot tell that a truck is overweight just from a cursory glance. They're abusing their authority to be able to put them on a scale and write them a ticket for thousands of dollars under the Frost laws. And this is technically, yes, it is illegal. So you need to think about that before you tell Leander they can just do whatever they want.